That if you've been convicted of any of those things,
I'm not sure if we say any of those offenses are just felonies.
Mr. Chairman and Representative Sands, Representative Smith, I believe it's just a felony conviction that keeps a card, keeps somebody from being issued a card. And so without really carefully looking through here, I'm thinking that these changes would not lead to an automatic revocation or a disbarment from participation in the program.
Ms. Representative Smith, I think under our Montana Constitution restoration of rights provision, the Senate Judiciary Committee felt that there were constitutional problems with prohibiting somebody from being a patient. Our legal analysis with respect to prior felony convictions for being a provider were, however, different because of the public safety issues involved. So that was the distinction that was present in the Senate bill.
Mr. Chairman, then we would maybe want to handle that different for a provider, because in this particular section, it looks like it treats cardholders and providers the same. And so my concern might be we have a provider that's violated the law. They haven't moved up to a felony, so they could be a card or a provider again, unless we have increased penalties for additional violations of the law to move it to a felony, or we put as a provision in there that says they've been convicted of a misdemeanor, that we don't allow them to be a provider.
And Mr. Chairman, I believe we did that by adding in the things that prohibit you from being a provider. It was a felony conviction or any drug-related conviction. Is that not correct? I don't know which version we put that in, but I think we put it in one of them.
Let's go back and look at that section while we're on it. I think this is worth some
Because my concern was that exactly that if you had any misdemeanor drug conviction, that you should be prohibited from being a provider, with recognition of what Senator Esmond said, that the Constitution does give full restoration of rights if you're the patient.
Mr. Chairman, members of the committee, on page 6 of the Salmon bill, line 29, it says the department may not register a person as a provider if they have a felony conviction or a conviction for a drug offense. I'm not sure that the offenses listed in this section would be considered a drug offense. In fact, I think they would not be. They'd be a violation of this statute, the act, and perhaps you would want to add that.
Mr. Chairman, can I propose that as a conceptual amendment wherever she needs to put it, whether it's back here in the provider requirements and also in this section, that any violation of this provision automatically revokes your ability to become a provider?
Thank you for them. Thank you. Members of the committee, before us we have a conceptual amendment as proposed by Representative Sands to indicate that violation of new section 15 in the red bill would reference to that would be added to line
29, I believe.
29 on page 6 of the salmon colored version of the bill, to include that as a disqualifying condition with receipt to being able to be a provider. Are we clear on that? Any discussion on that amendment? Senator Larson.
Mr. Chairman, I assume when we say they'd be prohibited, it means forever, right?
Mr. Chairman, under this, yes. And, we, I think, had discussions in earlier versions of this about is that for 10 years or whatever. At the moment, I would leave it that way and let future legislatures deal with it. To me, it's partly the issue, is this person honest and willing to comply with what the rules are? And if they have been convicted of this, it shows their character to be one where you cannot rely on them in the past, and I'm not sure you can in the present. As a health and safety issue, at least, And maybe future legislatures could take it up and say if it hasn't been in the last 10 years or whatever. But this is fraudulent representation under the current law. So that would be someone who's convicted under the current law, not something that happened 10 years ago. So I think it is very applicable.
Okay, further discussion?
Question.
Question having been called for on the conceptual amendment by Representative Sands. All those in favor indicate by saying aye. House members?
Aye.
Senate members? Aye. The amendment's on the bill. Good catch, Representative Smith. Ms. O'Connell.
Mr. Chairman, have amendments 122 through 125 been approved fully as conceptually amended? I just want to make sure that all those amendments should go on there along with the conceptual.
Mr. Chairman, I'll move all of them.
Thank you. I think we may have jumped off a motion, but we'll get back on track here. The motion now before the committee is to adopt amendments 122, 123, 124, and 125 to the bill. Any discussion?
Mr. Chair, that is with the conceptual amendment that we just added.
Correct.
Question.
Question having been called for. All those in favor indicate by saying aye.
Aye.
House members?
Aye.
Senate members? Aye. Amendments 122 through 125 are on the bill. Ms. O'Connell.
Mr. Chairman, Amendment 126 is a minor amendment to coordinate with House Bill 82, the bill to require the Board of Medical Examiners to report on physicians about whom they've received complaints. So this would just add the words except as provided in 37.2203, which is amended by House Bill 82 to Section 16 on page 18 of the red bill up at the top, so that the board would not be committing an offense of disclosure of confidential information if they release the names of physicians they've sanctioned, as House Bill 82 requires them to do.
I'll move the amendment, Mr. Chairman.
Representative Sands, discussion?
Question.
Ms. O'Connell, I have a question. We would, because the information that is going to be, that the Board of Medical Examiners is going to be required to report to the legislature with respect to the referrals they've received from the department, I don't believe personal identifying information is required in that report.
Correct.
Is that your understanding?
Mr. Chairman, that is my understanding, but I believe that House Bill 82 allows the department, or maybe even requires them, I don't have a copy, to disclose when they've sanctioned a physician for their practices related to written certifications. And because this exception was put into the existing medical marijuana law, and because those sections would be repealed, this language is needed in this new section to be consistent with House Bill 82.
Thank you.
Mr. Chairman, can we ask the board a question about their standard practice for releasing names of people who've been sanctioned? Because I don't think I've heard that response.
Without objection, please state your name, spell it for the committee. Secretary.
Mr. Chair, my name is Jean Branscombe, Branscum, and I'm the Executive Director for the Board of Medical Examiners. So, Mr. Chair and Representative Sands, the board does release the names of physicians once a decision has been made, and just how to kind of walk through that process is that a complaint will be filed with the board. That complaint is held as private information. Information goes to the physician and to the complainant, and that physician has a chance to respond. That goes to a screening panel that is still held in confidence. At the point in time that the screening panel finds there's reasonable cause, then information will go out to that physician. And at that point in time when that piece of literature goes out to that physician saying there's reasonable cause, then that information is public. That is when we can release information about that physician, the reasonable cause, and at that point in time there's negotiations between the physician and the attorney, and then a decision is made as to what the penalty or decision action would be made, and then that goes to an adjudication panel. All of that information is now public information, and that's the same type of information that would be provided to the legislature in this annual report.
Thank you, Ms. Branscombe. Further discussion by the committee? Seeing none. All those in favor of amendments
Just 126.
126, please indicate by saying aye. House members?
Aye.
Senate members? Aye. Aye. 126 is on the bill. Ms. O'Connell.
Mr. Chairman, amendments 127 through 130 are internal reference amendments that you've already approved. So amendments 131 and 132, I put in here as suggested clarifying amendments for the forfeiture section on page 19 and section 18 of the red bill. It simply said marijuana plants. I thought it was probably important to clarify again that it could be both mature plants and seedlings.
I'll move the adoption of the amendment.
Representative Sands, discussion by the committee. Question being called for. The motion before the committee is to adopt amendments 131 and 132 with respect and put it on the bill. All in favor indicate by saying aye. House members?
Aye.
Senate members? Aye. 131 and 132 are on the bill. Ms. O'Connell.
Mr. Chairman, Amendment 133 would add 2 new sections to the bill. One would prohibit advertising of marijuana or marijuana-related products in any medium. The other would provide for a hotline that the department would create and maintain to receive reports of suspected abuse. Both of those provisions were in the Senate version of the bill, and these amendments would add them back in.
Ms. O'Connell, I have a question with as you've set up the effective date, this prohibition on advertising would be effective immediately?
Yes, Mr. Chairman.
And the section on the hotline would be effective?
July 1st.
Thank you.
I'll move the adoption of the amendments, but I have a question, Mr. Chairman. Can one prohibit advertising? Is that not a free speech issue? I simply don't know.
Mr. Chairman.
Representative Smith.
Similar discussion came up in Billings when they were talking about the signage. And if I remember correctly from what they said, is they had the authority to limit size of signs, what's on a sign. I don't remember if it actually came up that they could totally limit signage completely. But you can certainly restrict what's on it, because we had taken out references to marijuana and marijuana symbols, plants, and all that kind of stuff. So I think we'd probably have to have legal tell us if you can actually do that with, and that was zoning laws we were talking about.
Yeah.
I'm going to express my opinion. You know, there are a series of U.S. Supreme Court cases that state that commercial speech is protected, as political speech is protected, as are other forms of speech. We are dealing in a gray area with respect to whether this is a legitimate commercial activity. I would state that there's not very much gray as of, with respect to this letter that was issued just Thursday with respect to enforcement of federal laws. Because 21 U.S.C. 843 makes it unlawful to use any communications facility to commit felony violations of the Controlled Substances Act. So with respect to that, I think the state of Montana could clearly take action with respect to prohibiting advertising because we are dealing with a controlled substance. And I would be doubtful that any court would uphold that there's a commercial right of free speech with respect to this activity.
Mr. Chairman, I think that's consistent, too, with what we've seen with we're not allowed to advertise tobacco in most forms on TV anymore, hard liquor, et cetera. So.
And Mr. Chairman, I had assumed that under the local control section that control of issues like commercial signage would have been included in there to the degree that local governments have signage regulation or could adopt additional signage regulation for businesses, which we hopefully won't have under this, but that they would be included there. And then I have just sort of a practical question, and perhaps it fits in this section, is when we get to the section of how does a person who has a card, find a person who is willing to grow for additional people? Could that be done through allowing the department to maintain a list of people who, upon request in your area, could, if they were willing, to have their names released to a card holder in that area? It's not advertising, but there needs to be some way to connect one to the other, and I don't think commercial advertising is the way to do it, but just so that in some way little old lady in Circle can find the grower in Brockway who's willing to grow for one more person and still be under their limit. Is there some way to accommodate that in some way?
Representative Smith, do you have an opinion?
I do. I think that's something we should stay away from. We don't want to be in the state in the business of I don't know, for a better word, enabling, linking up a person that has a need with a person that has. I mean, we don't do anything like that in the state, I don't think, for physicians or anything else like that. I think that is an area we should stay away from.
Representative Smith, I'm going to agree with you. Going back to, I think this is a question of incremental repair, and we're taking great strides today to repair this situation. If this becomes a problem, I'm certain that people can bring that to the legislature during the interim, and the next legislature can undertake a fix if it indeed is a problem. I think we're looking at a situation where family and friends are going to be functioning in a nonprofit compassion model to help seriously ill individuals. So,
Mr. Chairman, it also appears that this community is pretty active on the internet, and you can log on to their websites and find caregivers, providers in any state you want to at this point.
Senator Larson.
Mr. Chairman, I agree with both all the elements in 133. Advertising being prohibited makes a lot of sense to me. On the other hand, if we do that, then as Representative Sands points out, how can an aging person in a rural community find a caregiver, a grower for them, if we don't have some mechanism that would allow them to connect? So I'm going to support this amendment, but I oppose this discussion about not having a way for people to network to get the name of somebody who might be a provider. And with respect to advertising, the limitation on the number of people you can grow for is going to satisfy the problem about advertising, but I will still support this amendment.
Call the question.
Question having been called on amendments 130 on Amendment 133. All in favor indicate by saying aye. House members?
Aye.
Senate members? Aye. Amendment 133 is on the bill. Ms. O'Connell.
Mr. Chairman, it might be appropriate at this time to look at Representative Sands' one of our other suggested amendments, which is for another new section that would go in the new marijuana laws, the section for legislative monitoring, if you have that in front of you.
Representative Sands, would this be Amendment 7 on your?
Yes.
You want to go over this?
Yes. this section addresses the issue. We have another section in the bill that says reporting back to the next legislature, but in the interim, as I think you can all see, the involvement of the interim committee was very helpful to getting us to where we're at. And I just wanted to make sure that the legislature in the interim had that some interim committee had the responsibility for providing some kind of ongoing oversight of the department's activities relative to registering individuals, and at least having discussions and thinking about problems as they may emerge, and if they can come to agreement, developing proposals for the next legislature to consider. I mean, I think under their legislative authority, which is broad, they can do it already, but I think we should instruct them to do it, because whether it's the Law and Justice Committee, but at this point it has been the Children, Families, Health, and Human Services Interim Committee that has taken this on as a health-related issue. And so I just propose that we include asking for that interim legislative oversight, Mr. Chairman. And so I would move adoption of that new provision.
Thank you, Representative Sands. Discussion of the motion. Is this the appropriate interim committee? I guess so, if we put it on.
Mr. Chairman, it is the committee that has oversight responsibility for DPHHS, and that is how last interim we decided which interim committee should be involved with the issue.
I know they spent hours and hours on it.
Days and days.
Okay. Still working. Further discussion?
Question?
Question being called for. The motion is to add new section 17 dealing with legislative monitoring to the bill. All those in favor indicate by saying aye. House members?
Aye. Aye.
Senate members? Aye. That new section is added to the bill. Ms. O'Connell.
Mr. Chairman, amendments 134 through 136 you've already generally accepted as changes that need to be made. Amendment number 137 was put into the department's rulemaking authority when the other amendments existed, allowing the department to establish the limits for infused products providers in terms of the plants and amounts they may possess. So I'm thinking that this amendment is not necessary.
Would not be offered. Okay.
And then amendments 138 and 139, again, you've already accepted, along with 141, 144, and 145. So amendments 140, 142, and 143 were amendments I wanted to suggest to you to be added to the sections of law that are being amended to prohibit the use of telemedicine or electronic means by physicians. And the current language prevents them from using those means in 3 different sections of law to obtain the information required for the written certification. And now that there are more statements that the physician has to fill out, I thought you might want to include and accompanying statements to that language, so that it just reads that any of the materials that they have to submit, they cannot solely use electronic means.
So moved.
Thank you, Representative Sands. The motion before the committee is to adopt amendments 140, 142, and 143 with respect to adding that additional language to the telemedicine provisions. Discussion by the committee. Question being called for. All in favor indicate by saying aye. House members?
Aye. Aye.
Senate members? Aye. Aye. Amendments 140, 142, and 143 are on the bill. Ms. O'Connell.
Mr. Chairman, Amendment 146 pulls in 3 additional sections of law. The first one is 46-18-202, and that's one where we've discussed giving sentencing judges the explicit authority to have an offender surrender the registry identification card if they believe it's an appropriate condition for the sentence. So the underlined language there would be the new language in subsection 1F, and then subsection 3 requiring the judge to report the revocation or the surrender of the card to DPHHS so they could track that.
I'll move that amendment.
Thank you. We have amendment 146 before the committee. Discussion.
Call the question.
Question being called for. All in favor of adding Amendment 146 to the bill, please indicate by saying aye. House members?
Aye.
Senate members? Aye. Both bodies adopt. 146 is on the bill. Ms. O'Connell?
Mr. Chairman, the other two sections that are in that amendment are 50-46-201 and 202. If you choose to make the repeal of 50-46-103, which involves the issuance of cards, effective on passage and approval of this bill, then these are amendments that would be needed to address the fact that 54-46-103 was out of existence for 3 months until the rest of the Medical Marijuana Act was repealed.
So, Ms. O'Connell, this would be necessary for the transition scheme as set up in this bill.
Yes, Mr. Chairman.
Question, Mr. Chairman. So is this a section that provides, I just want to make sure that a person who has a card doesn't, because we're repealing the existing law, still has a valid card, and that doesn't immediately go out of?
Representative Sands, I believe that is handled explicitly in the transition section, which we will get to.
Great. Okay, thank you. Then I'll move this amendment.
The amendment before the committee is the balance of Amendment 146, which includes Section 28 amending 50-46-201 and Section 29 amending 50-46-202. Discussion from the committee.
Question?
Seeing none, all those in favor of including those changes on the bill, please indicate by saying aye. House members?
Aye.
Senate members? Aye. Both bodies adopt. Those changes are on the bill. Ms. O'Connell.
Mr. Chairman, Amendment 147 would add a new making authority so that they could suspend some of the traditional or the required public notice, public comment periods and adopt rules so that they could start issuing the new registry identification cards June 1st under the provisions of the new law that would be approved.
I'll move that amendment.
Thank you. Representative Sands. Ms. O'Connell, just so I can refresh my memory, the bill as it would stand would, adding this amendment would allow the department to adopt emergency rules so that they can issue the new laminated cards, which are uniquely numbered, to all existing cardholders beginning June 1, 2011. Is that
Mr.
the way
Chairman,
you understand it?
That is my understanding, so that whatever rules they felt they needed to have in place to accommodate the new provisions of the law, they could adopt emergency rules and start issuing the cards June 1st to both the patients and the providers.
So those reissued cards would be strictly to cover the period for which the currently existing cards cover, not an extension of time under the reissuance provision. Is that correct?
Mr. Chairman, I'm not sure that is correct. My understanding of the transition section is that they would begin issuing cards, and those cards would be valid for 1 year unless a physician said they should be valid for a shorter period of time. If I misunderstood what your intent was, we can work on changes to that. But my understanding was that they would be able to issue new cards, and those cards would be valid for the same time period as they currently are.
Mr. Chairman?
Representative Smith.
That would have been the same interpretation I would have had reading through it, too, that we would not take a card that was issued under the old provisions and replace it with a new one. This would be for new cards going forward. That's the way I read the bill also.
Senator Larson, excuse me.
I'll be whatever you want me to be right now. I thought in our discussions that was how we phased this, because you stop every single one of these 30,000 people on the same date and we're going to have chaos. So I thought that was on a calendar date. When they expire, they get issued a new one if they qualify under the new rules.
Mm-hmm.
Senator Representative Smith.
That was my understanding too, but I didn't read in the bill that we'd be issuing a new card
For the,
for the remainder of the period of time. Let's say somebody received a card in January. I didn't see the language in here that would indicate that we would give that person a new card that would be good through the end of January. We would just let the current cards expire is the way I read it. But I think the point you're bringing up is certainly valid.
okay, so let's recap this then. The way the bill is currently drafted, existing cards could continue to be possessed through their period of normal expiration. The emergency rulemaking provision included in this section, this new section, would be for new cards issued under the new rules only.
And Mr. Chairman, that would include cards issued to providers so that when the caregiver cards expire on June 30th because of the repeal, it's possible that some providers could have their cards and be operating, so that the department again is not doesn't have thousands of people applying to become providers.
So the patient card holders, their cards would remain good. The provider card holders, their cards would expire on July 1, and new cards would need to be issued.
Mr. Chairman, the trick, it seems to me, is that the card holder, their card goes forward, but since they're required to name, either say they're going to grow it themselves or who's going to grow it for them or provide for them, many of them will still have to approach the department under some process and indicate that, this big grow operation out here no longer is going to exist. And so they have got to name and say either I'm going to start growing it for myself or I'm going to name so-and-so to do it. And they're required under the law within 10 days, I think, to do that notification. And that's going to put additional time and responsibilities on the department to accommodate that. And a large number of people will need to do that, even though their core card stays valid. They're still going to have to let the department know how they're going to handle this situation.
Thank you, Representative Sands. So then I'm assuming at that point the new laminated card is going to go out, but it's only going to be for the existing period of time.
Yes.
Since it's a replacement card. We may want to visit that in the transition section just to make sure we've dotted that I and crossed that T.
I believe that's why emergency rulemaking is probably critical
Okay.
here.
Further discussion by the committee?
Did we move that section? I'll
It
move
has been moved.
Okay.
We're still discussing it.
I think we've agreed that we need it. We just haven't exactly decided what it'll do.
Okay. Thank you.
Oh, Mr. Chairman, I think the language is broad enough that we sort of give the department some flexibility that if they need to allowing for the issuance of the cards in conjunction with the provisions we've made, they have a little bit of flexibility to make sure that those loopholes are addressed.
Thank
Question.
you. Question being called for. We are voting on amendment number 147 to add section 31, which provides emergency rulemaking power to the department. All in favor indicate by saying aye. House members?
Aye.
Senate members? Aye. Both bodies adopt. 147 is on the bill. Ms. O'Connell.
Mr. Chairman, amendments 148 through 151 on the last page all deal with the transition section. So I think if you look at page 29 of the red bill, you'll see how all of those would be incorporated. So the first change clarifies that the registry identification cards for patients that were issued before 5046-103 was repealed on passage and approval are valid until the expiration date listed on the card. So if somebody receives a card today, it is valid until next April 18th. Then new subsections 2 and 3 go in, giving the department the ability to start issuing new cards to either patients or providers starting June 1st under their emergency rules, and giving providers until October 1st to get their fingerprints taken and submitted, and the department to get the results of background checks back, so that during this interim period, the department could go ahead and register a provider without knowing whether or not that fingerprint background check is going to eliminate them as a provider, so that there is some ability for patients to continue to obtain the marijuana. And then in subsection 3, if somebody fails to submit their fingerprints by October 1st, or the results of the check show that they should not be issued a card, the department will revoke the card they've issued and notify the patient. And then subsection 4, there are some amendments to just clarify that if you have a card as a caregiver that was issued before the effective date of the repeal of the issuance of cards, you can still have your plants until July 1st, but when full repeal goes in, then you cannot have those plants, seedlings, usable marijuana, or any products on July 1st if you haven't gotten a card as a provider. And if you haven't gotten a card as a provider, you need to take all of those items to your local law enforcement agency for destruction.